doesn't do anything.
A lot.
He gets frustrated.
A lot.
Okay? Maybe the frustration level comes to a point that I'll go public now. Okay? So, fine. You can, the person against who he is alleged and himself, you can certainly hold him to task by saying, prove this allegation. And the other person who's alleged it will say, you made a false allegation, I'll show it. Which is exactly what's happened in this case.
But may I
so how this is, which other article can you rely upon?
This is the only article, I suppose. But there is an article which was invoked in the order itself.
Which one was that?
Kindly read its second para of Article 2.
I'm going to read that. Right. Second para,
Second para of Article 2.
In the matter of taking his seat and of rising from his seat, he shall be punctilious in point of time, mindful of the courtesies, careful to preserve the dignity of the court, while maintaining an equal aspect towards all litigants, as well as lawyers appearing before him.
He should be careful to preserve the dignity of the court.
Yes.
Yes.
This is, but Lord, I think
you are saying it comes under this too.
Lord, what I'm saying is that these are the provisions which can be.
No. Tell me which one.
My Lord, I said Article 5 and Article 2, subpara 2 also comes within that because my Lord,
we have an advantage in having you before us.
Lord, I'm grateful for
so the advantage is you are now well versed with SJC matters. Okay. The other SJC matters where you are proceeding again. One is finishing a complaint. Right? You don't have to inquire into great details of every frivolous kind of allegation. You can just dispose it off, consign it to the record or whatever it's called. But where you proceeding against a judge? Why you proceed against a judge? With a view to remove him. So you have to give him some. I mean, here you may be conflicted as a lawyer. I'm not saying conflicted in this case, because your contentions at other place may be different. You will say, establish this thing. Fair enough. The burden on whoever lies the burden will establish it or not establish it. It doesn't get established. Clean bill of health.
देखिए आर्टिकल 2 सब इसके सेकंड पैरा में लिखा है टू प्रिजर्व द डिग्निटी ऑफ द कोर्ट। जो एलिगेशन इन्होंने लगाई है वो तो डिग्निटी ऑफ कोर्ट के अगेंस्ट है, तो इसको प्रिजर्व कैसे करें ये आपसे पूछे। उन्होंने एक तकरीर में कर दी। दूसरा तरीका आप बता दें कि कैसे कर सकते हैं।
उसका तरीका मैंने बताया ना, जो एलिगेशन लगा रहे हैं व्हाट इज I again let me again reiterate, I'm not taking sides. I'm saying if it can be stretched, that speech and conduct in terms of that speech can be stretched, it could at best fall within these articles, and there's nothing beyond that. Article 5 or at this subpara 2 of Article 2. And this is for this honorable court to decide whether that speech, irrespective of whether it is based on truth or otherwise, comes up to that standard of falls within this mischief or not. That is all. As far as the inquiry part is concerned, that did not take place. So there were, and those specific allegations are not there in the speech. The order itself, when we read page 7, we read the conclusion, it is basically focused on the speech itself, which is said to be the reason why the removal is being recommended. It's not the question of any other issues that were raised there, because they were not inquired to. Yes, to the extent of the Honorable Chief Justice, the reply was sought, and that reply came, and whatever the Honorable Chief Justice said was against what the petitioner was contending.
Did the Chief Justice, was he examined?
No, he gave a letter. So it's all a question. If this is a matter which goes on to inquiry, then yes.
But then it will mean that there must be a standard why you are believing the Chief Justice and disbelieving a judge.
What I'm going to saying is going back to the observation.
Is it the status which?
No, not at all. Not at all. It was just. I am not even supporting that. I am not supporting that because the Honorable Chief Justice said something, therefore believe him and not believe the other part. I'm saying if this Honorable Bench comes to the conclusion that in this matter, irrespective of the contents of the inquiry itself, the speech itself, and that it was made publicly addressed to a bar association, which was then, if this is fine, this is all right, this does not amount to misconduct, then the order that this honorable court has to pass, the way to move forward is to exonerate him of the charges of making a speech which does not come within the ambit of misconduct. It does not imply that whatever he said was true or that it necessarily needs to be.
But if you read the order, it is 39 pages of the order.
Yes.
Content is there. If there was no content there, I mean, I would find it very strange that the mayor making of a speech.
I have submitted, my lord, that in the order itself there is a mixture of the presumption that what was being said by him in terms of allegations were not true, without an inquiry. I've already said that is part of the order itself. Okay. What the conclusion would be then that this particular list would come to an end with the petitioner being exonerated of the charges, the order being set aside, the recommendation being quashed, and he gets whatever he gets. But beyond that, if this honorable court wants to go into whatever the petitioner says, it has to go out of this list.
Khwaja Sahab, this nation has suffered enough. Now, it's not a question of granting relief to a particular person or withholding a relief from a particular individual. As far as I'm concerned, that's least of my concerns. My concerns are the integrity of the institutions. If the allegation level is true, I mean, the nation wants to know the truth of the matter. This person is telling the truth or that person is telling the truth. You say, no, forget it. Leave it aside. It's not a small matter of a small office holder post. It's a institutional matter. Don't you, let me ask you very candidly, as a senior lawyer, would you not want to know the truth of the matter, that the petitioner is telling the truth or your client is telling the truth? Just as you have invested your life in this profession. Yes, what would you not want to know the truth of the matter?
This is exactly what I'm saying. I am with your lordship on that.
How do you get to it?
What I'm saying is that not in this list, not in the case before.
So how do we do it?
That your lordship takes suo motu action or takes some other action, but not any. It cannot be.
One इनकी एक तजवीज़ आई है कि send it for review, remand it to the Supreme Judicial Council, that Article 209(7) was not complied with, and 205 and 6 all use the word inquiry, and 7 says you cannot remove it unless you follow the procedure. So that was not done. Without this court determining it, could the Supreme Judicial Council re-examine it and determine it once and for all whether, I mean, I think the nation needs to know whether the allegation is true or false. Leave aside your interest and his interest. There is an interest of the nation. You come from an institution which is paid out by the public exchequer. The petitioner comes from an institution which is paid out of the public exchequer. These institutions are not for your personal benefits. They are there to serve the people. So what do we do with it? People will make fun of it. What have you come up with, the result? Who was telling the truth in this matter? Because the truth is diametrically opposed. He's saying one thing, you're saying the opposite. It's not a question of variation of the truth. He misunderstood me, I meant this. Then we could have maybe reconciled both versions. तो ये जरा बताएं, इसको सॉल्व करें.
जैसे गुजारिश की, what my learned friend has said, if he has proposed, if he is sticking to that the matter can go back to the Supreme Judicial Council.
Can it?
I see a legal impediment that the Supreme Judicial Council is not cut out, is not constituted, it's not part of the Constitution for the purpose of making an inquiry which does not involve the recommendation made to the President for removal or otherwise of that of a judge. That part of the function has already come to an end.
Are you then suggesting a complaint is filed against a judge, or as in this case by the registrar, whatever you want to call it, without inquiring into the complaint, Supreme Judicial Council says he's removed, recommends to the President, remove him. That's it. End of story.
The petition is here for the purpose of getting it quashed precisely for this reason.
I'm saying that is the one person, but This is not a matter of one person, it's a matter of the independence of the judiciary, which the people of Pakistan have invested into it. They're not interested in a judge serving or not serving. This matter has gone into the public domain now. It has to be, the public has to be satisfied one way or the other. Who was telling the truth? Well, truth doesn't matter anymore. I keep emphasizing on truth. If he's truth, I think all the maslas will go away.
Just as it was open.
Aren't you personally interested just to know?
No, yes. May I make a submission?
Burning inside you.
But not within the framework of law, within the framework of constitution, yes. We all want to know the truth, absolutely. But we have to remain within the frame. I do not see
which provision prohibits such an order. I'm just thinking aloud.
ये जो केस है आपके पास
नहीं ये ऐसी जनरल बात कर रहे हैं. अगर एक और कल को केस आ जाए, कंप्लेंट हमारे पास पढ़ने नहीं बहुत सारी पड़ी हुई है, आती जाएंगी, मुझे कोई जज नहीं पसंद है, चलो हटा दो इसको, सारे हमारे सुप्रीम जुडिशल मेंबर्स अग्री कर लें, हाँ हटा दो, कोई हम इंक्वायरी करें कुछ ना करें, आपको बस खत्म हो गई बात, अब कुछ नहीं कर सकते हैं.
पिटीशन आती है, एक पिटीशन.
अगर देखिए एक बात है सब्स्टिट्यूटिंग योर ओपिनियन फॉर someone else, that's a different matter. The other is inquiring into the matter. Even a murderer has committed murder in front of everybody, you still have to go through the process. I mean, even if someone commits murder right in front of 100, 200 people sitting in this room, we can't just say hang him. No, we'll have to frame a charge, we'll have to bring witnesses, we'll have to give an opportunity for cross-examination. Total waste of time, you will say. Yes, that's what rule of law means. Total waste of time. Sometimes it amounts to that. I'm just trying to, each decision creates a precedent. So where should we go now from here?
As I keep saying, my lord, the order gets quashed if dishonorable bench comes to the conclusion.
Then the nation will hold us accountable.
Necessary, notwithstanding the allegations made.
If you have finished, can we request the Attorney General?
Please.
Huh?
Yes.
Okay.
I made my submission.
Have you understood, because you came in late? From what let's just quickly recap everything. The petitioner made allegations in a speech to a bar. One is, you shouldn't speak to the bar at all, end of story, go home. The other is that the speech was so, whatever, it was not pleasant for someone or the other. And nonetheless, it was made. Now the content is either true or false. It is admitted on all sides that the Supreme Judicial Council did not inquire into the matter. The word inquiry, Khan Sahib has said, is finds mentioned twice, 5, again in 2096, and 2097 says you can't remove it unless this. Okay? To proceed further, you have to inquire into the matter, not to finish a complaint. If the complaint was consigned to the record, that's not the issue. But when you are proceeding against a judge, then Khan Sahib has said, where is my due process? Where is my right to, if everybody comes before me asking for right to fair trial. Now we come to the situation, where do we go from here?
And the most important thing is that the allegation has been leveled against the institution, which is more important as far as I am concerned. ये इसके तहकीकात होनी चाहिए या नहीं होनी चाहिए, बस हवा में उड़ा.
और एक चीज और, ख्वाजा साहब has also said one more thing, something important. He said once he's been removed and he's attained the age of superannuation, the matter ends. Now we were hearing some other case.
Yes,
the same issue came up there also.
So my lord, as far as not following or not conducting the inquiry is concerned, that is contrary to law, and that to my mind would be malice in law, and therefore Article 211's ouster would not apply as far as this petition.
Which ouster?
211, sir. Article 211.
What does it say?
Bar of jurisdiction.
Bar on jurisdiction, my lord.
The number of judgments.
So I think that's quite settled. So if the inquiry hasn't been followed, on the basis of it being there being malafide in law, Article 211 does not apply. Therefore, this court would have jurisdiction.
Malafide law.
No, but Malafide law is basically, if the process is not followed, if what the law or the constitution requires is not followed, it is Malafide law. Not in fact, but in law. So because if that is so, then this court has jurisdiction, so the court can proceed. The court can look into the movement.
We are not a substitute for the Supreme Judicial Council.
Of course you're not, but now the question...
We can't say, okay, now please come and give oath and give it on statement I will cross-examine.
No, this is jurisdictional question. This is jurisdictional question. You're not going to inquire into the matter while sitting as a court. The Supreme Judicial Council's, it is Supreme Judicial Council's remit to look into that matter, but I am just only saying that this court has jurisdiction to hear the petition if the inquiry has not been conducted, 209, and the procedure has not been
crossed that bridge.
So yes. So once that is done,
where do we go from here?
Once that is done, now one fact which has which was alluded to, and there is a judgment, a two-member bench's judgment in Afia Sheher Banu Zia's case, BLD 2023 Supreme Court 510, wherein the two-member bench has held that if a judge has resigned or has retired, the proceedings, if while he was on the bench had commenced before SJC, they would abate. Now, the federal government, I had in another matter stated before your lordship that the federal government intends to file an appeal against that judgment.
Has it been filed?
Yes, my lord, it has been filed.
What number hai?
My lord, it has yet to be numbered. I hope it will be numbered today or tomorrow. Now, there are several problems with that judgment, and of course...
If the principle of that judgment is sustained, then it effectively cuts both sides. Then a judge who's been unconstitutionally removed can do nothing.
Now, so in
the meantime, he retired, for instance.
So in this case,
he attained the age of superannuation.
So in this case, the distinction also is that after the judge was, the petitioner was removed, he had essayed those proceedings before this court, and he had not attained the age of superannuation at that time. So that distinction being there, but that judgment needs to be revisited also by this bench or any other bench in order for the court to then pass the order of setting aside the Supreme Judicial Council's order in this case also.
Yeah, I'm not clear with you. Are you saying that we should attach that case with this case?
I would submit so, my lord.
Achha. Okay.
And now, if the inquiry process has not been followed, and the allegation, now we don't know what
is remand permissible?
If, my lord,
if you are saying if Afia is sustained, then it probably may not be. Is that what I'm not understanding?
If Afia is sustained, then perhaps in this case, they may still have to, the petitioner may still have an argument to make, which is that he had not attained the age of superannuation when he had challenged the Supreme Judicial Council's order before this court. So there would be that distinction.
But I think there is a fact is that the list in some form or the other was before this court.
That's right. So that's what I was alluding to. That if there would still be a distinction as far as this particular case.
If we accept this petition,
yeah,
what will happen? So we simply
things can happen. Two things can happen. If my lords accept this petition and simply set aside the Supreme Judicial Council's order without remanding it, then he would be treated as a judge who would retire.
We are also concerned about the allegations. What would happen to the allegations?
Suppose, with due respect to the petitioner and his counsel, suppose we set aside the order and he is laughing. All that I said was false. Okay? Nation, I think I'm more concerned that every case we decide we have to keep half an eye out. Iska implication generally kya hoga? You may want to do something, but it may have wide ranging implications. The other thing is, doesn't the nation want to know one way or the other? What is the position of the federal government on this? Well, wouldn't you want to, as they say, get to the truth of the matter?
My lord, so I just got called on short notice.
I know that's not fair.
What I can state here is that now there are certain allegations which are made in this petition, and those allegations, from what I've understood while sitting here, have been denied.
Not some minor allegations, some serious allegations.
Those allegations have been denied, and now obviously this court cannot record evidence. Is not the forum for doing it. Is there a solution? The solution, my lord, is that in order to look at the entire matter in totality, if Afia Zia is overturned.
इस्लामाबाद में साबिक जज इस्लामाबाद हाई कोर्ट शौकत अजीज सदीकी की बरतरफी के खिलाफ अपील पर सुप्रीम कोर्ट में समाअत जारी है।
वापस आएंगे ब्रेक के बाद।
आप हमारे साथ।
गाड़ी से शर की जड़ उछला, शुक्र है मैं बच गई।